I'm just gonna make a
Good evening and welcome to the Tuesday, April 11th, 2023 meeting of the Ashland Zoning Board of Appeals. In accordance with the governor's order suspending certain provisions of the open meeting law, General Laws, Chapter 30A, Section 20, this public meeting is being conducted remotely. And please be advised that this meeting is being recorded and broadcast on WACA. To participate remotely, you may log into the Zoom instructions on the agenda, or there is also a telephone number listed on the agenda that you can call in on. First order of business will be the meeting to order. I, John Trefethen, am present.
Hi, Brian Forrestall, I'm present.
I, Nathan Band, am present.
I, Stuart Siegel, am present.
Brian, this is where you identify yourself.
Yes, I, Ryan Sullivan, am present.
Excellent. And we welcome our newest associate member of the ZBA, Ryan Sullivan. He was appointed by the Select Board recently, and this is his first meeting. So welcome.
Thank you. Pleased to be here.
Okay. Item number 2 on the agenda is a discussion with Suneetha Karra. I've been advised that she will be joining us in several minutes. So I am going to suggest that we go down to item number 4 of the agenda, the meeting minutes of February 28th and March 14th. And specifically, at our March 14th meeting, when we were considering the minutes of the February 28th meeting, Nathan had raised an issue as to whether the February 28th minutes adequately reflected the pre-existing tenants in 2017, which were referenced at our February 28th hearing. And we tabled that item until tonight to give us all an opportunity to review our notes, review WACA's video recording, and determine whether or not the minutes as presented accurately and adequately identified the subject. Nathan, did you have an opportunity to review and determine whether the minutes were up to your satisfaction?
Yeah, the updated minutes, I think, reflect that conversation.
Okay. And the reason I'm taking this out of order is because I think it's important when we get to the hearing tonight that we all know what the minutes from the previous hearings were. Any other questions about the February 28th minutes? Someone wish to make a motion to approve the February 28th, 2023 minutes as presented?
So moved.
And is there a second? Someone wish to second?
I second.
Oh, okay.
Brian Sullivan.
Okay, I, John Trefethen, vote in favor. Brian, are you with us?
Excuse me, John, town planner. Ryan, I love your enthusiasm, but since you were not a member of the
Right.
board, I would ask if someone else would move forward and second that application. I mean, second
you.
the minute, please.
Is a member of the board.
I'm sorry, Stu, was that a second? I didn't quite hear.
I thought Ryan was a member of the board.
He is, but he wasn't as of
Oh, okay.
February 28th.
I'll second the
Okay,
minute.
thank you. Peter's a stickler for our Robert's Rules of Order, I think, which is probably a good thing.
I
John Trefethen, vote in favor. Brian, we can't hear you. Still no luck. You want to call in? And you can be on the video, but also on the audio, on the telephone?
Is it Ryan who's stuck?
No, it's a Brian.
Oh, Brian.
I, Brian Forrestall, vote in favor.
There we go.
Sorry about
All
that.
right.
Little audio problem.
I, Nathan Band, vote in favor.
I, Stuart Siegel, vote in favor.
Excellent. Okay, moving on to the March 14th, 2023 minutes, fairly brief. Did everybody have an opportunity to review them? And are there any proposed changes or questions about them? If not, is there a motion to approve the minutes of our March 14th, 2023 meeting?
So moved.
And is there a second?
Seconded.
Okay. I, John Trefethen, vote in favor.
I, Brian Forrestall, vote in favor.
I, Nathan Band, vote in favor.
I, Stuart Siegel, vote in favor.
Excellent. Okay, that takes care of that. I don't see that our discussion person, Suneetha, is signed on yet. And the only other item of substance on the agenda is the continued hearing for 59 West Union Street, which I would anticipate would go on for a fair amount of time this evening. Peter, how do you want to handle the agenda so we can move things along and not unduly delay everything?
I think it makes sense, John. Well, number one, I do want to take this opportunity to introduce to the Zoning Board of Appeals and all others, Mr. Alvaro Espaza. Sorry, Alvaro. Alvaro is our new assistant planner. And so Alvaro, this is his first Zoning Board of Appeals meeting. I know John has met Alvaro in the office, but first I want to introduce Alvaro. Alvaro comes to Ashland from the city of Worcester and a graduate of Clark University. So now first and foremost, welcome Alvaro to the Ashland Zoning Board of Appeals. With that statement, John, I do think, in regards to our item two, I think in correspondence, Suneetha did plan and was available to join the meeting at 7:15. So if we want to take a 3-minute break to see if Suneetha can join us at 7:15, she has been on a couple zoning board of appeals agendas that makes sense and is appropriate, and then we can open up the discussion for 59 West Union Street.
Do we need a motion to go to take a break or whatever you want to call it, or can we just
I think we can do a motion to take a break, and/or I think as you as chair, you have the ability to announce that we will take a break at 7:15.
okay, why don't we short circuit things and we'll take a 5-minute break at 7:15. Let's come back at 7:20. If Suneetha has not been able to join us by then, we'll move on to the next item on the agenda. Okay? Okay, thank you, everybody. our guest, Ms. Karra, has signed on, so I think we should go back on the record and continue with our hearing.
I I agree. It's 7:18. I think we said 7:20. We will come back in session.
Okay, I was just going by the time on my computer,
Oh,
so
excuse me, on your computer. Yep.
I
I have 7:18, but I'm happy to.
why don't we get started? And
Okay.
WACA, however you get us back to an open meeting, do you count me down again? Okay, good evening. Welcome. We have resumed the April meeting, April 11th, and let us continue with the next item on our agenda, listed as item number 3, 59 West Union Street, continued public hearing. Matter continued from March 14th of 2023. The hearing was opened on February 14th, continued to February 28th, continued thereafter to March 14th, and from March 14th, continued to this evening. I'll briefly read the notice. The Ashland Zoning Board of Appeals will reopen and continue the public hearing to hear the petition of Emery Bond and Brandon Bond, trustees of the Island Pond Trust, who have applied to the ZBA to repeal the building commissioner's determination under Ashland Zoning Bylaws, section 9.2.2.3, parenthesis, Board of Appeals, close parenthesis, along with any other applicable sections of the Ashland Zoning Bylaws. The Building Commission's enforcement letter dated November 31st, 2022 states the recent expansion of the pre-existing non-conforming uses in violation of the Ashland Bylaws. The property in question is located at 59 West Union Street, Assessors Map 19, Lot 63 in the Highway Commerce Zoning District, and parties wishing to be heard on this matter should appear at the time and place indicated above. All that being said, members of the board, I wanted to discuss briefly a procedural matter for us this evening. You will recall that at our February 28th hearing, we closed public comment by motion. Subsequent to that date, there has been significant additional evidence that has been filed with the ZBA, and which also will be subject to discussion tonight by, I'm sure, Attorney Connors and other members of the board. And I think it's appropriate that we reopen public comment to give people an opportunity, if they so desire, to address the ZBA on any new matters that may have come up, as opposed to rehashing matters that they may have addressed at a prior hearing. What do people think about that?
Sounds like a great idea.
Yeah, I've got no problem reopening comment as long as it is tightly limited to the new material.
I would agree with that. Stu, you all set with that?
Yes, sir.
And Ryan, you okay with that?
I am, yes.
Okay. I wish to make a motion to reopen public comment.
So moved.
Is there a second?
Seconded.
Okay, I, John Trefethan, vote in favor.
I, Brian Forrester, I'll vote in favor.
I, Nathan Band, vote in favor.
I, Stuart Siegel, vote in favor.
I, Ryan Sullivan, vote in favor.
Excellent. Okay. Moving along, Attorney Connors, I see you're here and welcome. And I see your clients are also here, and welcome to them as well as other members of the public that I see signed on. As I indicated, and for the benefit of the public, we'll have public comment again at the conclusion after the applicant has made any presentation they wish to make, and after the board members have had an opportunity to ask questions, and then there'll be time for public comment if anyone wishes to be heard. As I indicated, there has been several pieces of evidence that have been filed with the ZBA and will be entered as part of the record of this hearing. I'm not going to read all of them. I believe they have been distributed amongst all the ZBA members and also on the website, but I will just identify what those documents are. The first document is a response by the applicants to the memorandum that was submitted by, and I'm going to blank on the name and I apologize. Find the minutes. Mr. Rodenheiser, I apologize for blanking on your last name.
That's all right.
And as I said, the document is the response that the applicants filed to the document that Mr. Rodenheiser submitted on the first date of hearing, February 28th. In addition, there is a letter from Doug Scott, our building commissioner, addressed to me as chairman of the Zoning Board of Appeals regarding 59 West Union Street, dated March 8th, 2023. It's a little more than one page. It was in response to our request to the building commissioner that he amplify his previous letter, which was erroneously dated November 31st, 2022, but which is the letter that is being appealed from. And Mr. Scott says as follows: "It is my understanding that the zoning board would like a synopsis of how I arrived at the determination that the land use (parenthesis contractor's yard) close parenthesis at 59 West Union Street is considered pre-existing non-conforming. 59 West Union Street is located in a highway commerce zone. The Ashland Zoning Bylaw provides as follows, Section 3.3, non-conforming uses and structures. Section 3.3.1, applicability. This zoning bylaw shall not apply to structures or uses lawfully in existence or lawfully begun, or to a building or special permit issued before the first publication of notice of the public hearing required by General Laws, Chapter 48, Section 5, at which this zoning bylaw or any relevant part thereof was adopted. Such prior lawfully existing non-conforming uses and structures may continue, provided that," and then in bold type, "no modification of the use or structure is accomplished under authorized hereunder, unless authorized hereunder." And then 3.3.2, non-conforming uses. The Board of Appeals may award a special permit to change a non-conforming use in accordance with this section only if it determines that such a change or extension shall not be substantially more detrimental than the existing non-conforming use to the neighborhood. The following types of changes to non-conforming uses Any be considered by the Board of Appeals. A, change or substantial extension of use. B, change from one non-conforming use to another, less detrimental non-conforming use. In the fall of 2019, the zoning (parenthesis highway commerce) close parenthesis was changed to not, in capital letters, allow contractors' yards and landscaping businesses. By this change, the current use (parenthesis contractor's yard close parenthesis) became a pre-existing non-conforming use. The owners of the property had leased out a portion of their property to a landscaping business, which is currently not an allowed use. This new landscaping business is in addition to the uses which existed prior to the change in the bylaw. Therefore, my determination that this new use (parenthesis landscaping business close parenthesis) is not an allowed use and would require a hearing for a special permit to determine if any of the criteria in section 3.3.2 A and B are satisfied. It is my opinion that the new landscaping business is not an expansion of an existing use on the property. It is the addition of another use currently not allowed in this zone. And that concludes Mr. Scott's letter. Next is a letter addressed to the Ashland Zoning Board of Appeals dated March 13th, 2023 regarding 59 West Union Street, and a finding addressed to dear members of the board from attorney George Connors, consisting of 4 pages. And this contains the legal citations that attorney Connors wanted to submit to the board. And due to some miscommunication, they weren't submitted to us in time for the March 28th hearing. And then finally, there is a letter dated April 6, 2023, but received by the Ashland Planning Board, or stamped at least, of April 11th, addressed to the Zoning Board of Appeals, John F. Trefethen Chair, Town Hall, 100 Main Street, Ashland, Mass. Dear Mr. Trefethen, I am writing to inform you that I was never notified about the public hearing of the Zoning Board of Appeals on February 14th, 2023. As the owner of 81 West Union Street, LLC, and a direct abutter of 59 West Union Street, Ashland, Mass., I should have been notified in advance of the meeting. The first time that I became aware of any meetings or any activity as it relates to 59 West Union Street, when a friend called me after the meeting had already started. Please add my name and contact information to the abutters list. Sincerely, William Rodenheiser, 81 West Union Street, LLC, 70 Bartsack Drive, Halston, Mass. 01746. And that will also be entered into the record. And that being said, Mr. Connors, do you want to make any statements at this point, a presentation further before we invite the board members to ask any questions that they might have?
I think briefly, sure. Can you hear me?
We can.
I think briefly, as you indicated, there was a letter from the bonds regarding a response to the 81 Main Street memo from the last meeting. And I think that is pretty self-explanatory. I don't know that it has much to do with the actual zoning issues they are. And then my response was one that I asked you if I could outline the ability of the board to make a finding in this particular matter. And I think that is somewhat in juxtaposition to your building inspector's letter, where he cites 3.3.2 in your zoning bylaws. 48.6 provides for a finding where there's a substantial extension of the use, and I don't think that's the situation here. Notwithstanding that, it would appear that 3.3.2 requires a special permit. And I would suggest that any change in the town for a pre-existing non-conforming use, whether it be minimal or minor or maybe even substantial, would require a special permit. And I don't think that's the intent of 48.6. Finding is allowed by both the zoning board or the building inspector to determine whether this is a substantial extension and a substantial impact from that extension on the neighborhood. And as I indicated in that letter, there were a few cases, and there are many, indicating where a lot more has taken place on similar type applications. I'd end my response at that point and here to address any questions or comments you may have. Thank you.
Okay. Brian, questions for Mr. Connors or for the bonds?
I don't have any questions at this time.
Okay. And Nathan, how about you?
So I guess, Attorney Connors, correct me if I'm wrong here, but all you're looking for us to do here is the appeal of the building commissioner's letter, right? There are no, this discussion of kind of a section 6 finding is tangential to what we're considering here today. Is that correct?
No, we want a section 6 finding by your board saying that the use is not substantially more or has a substantial impact on the neighborhood, and therefore the pre-existing nonconformity is not in violation.
So again, stop me if I'm way off, but my understanding of your appeal of the building commissioner's letter was that there was no expansion of the, or, you know, substantial change to the pre-existing use. And so no grounds for the building commissioner to find a violation.
And no ground for the bonds to have to avail themselves of a special permit application.
So my confusion is, if your assertion is that there is no substantial expansion or change to the pre-existing use, why a section 6 finding? Isn't that a tool that we would use to legitimize an expansion or a substantial change?
Not legitimize, I take exception to that word. To recognize that there is no substantial expansion or a substantial expansion that has a substantial impact on the neighborhood. In other words, the bonds can continue to operate as they do without the necessity of a special permit.
So I'm just looking at section 6 here, right? Pre-existing non-conforming structures or uses may be extended or altered, providing that no such extension or alteration shall be permitted unless there is a finding by the permit granting authority or special permit granting authority that such change, extension, or alteration shall not be substantially more. So if there's no change or alteration, what are we finding? Are you asking for a section 6 finding that there is no change or alteration?
Yes. That's,
All right,
that's
that seems
not substantial. You can have a small change or alteration. If you look at my letter on the second page, it indicates 4 particular cases where an increase in volume of wholesale retail sales was not an increase. Additional buses that were stored on a premises were not increases in.
But were those done through a section 6 finding, or were those just ruled?
Yes.
There's no, okay.
Yes, yes, yes.
Okay. All right, that
And-
clears that up for me then. Thank you.
I just want to make one point in that a building inspector can make that same finding that you can.
All right, thank you.
Stu, questions for Attorney Connors?
Mr. Chairman, we had a submission by town council with regard to this. Could we summarize that and
Sure.
relate it to the information that was just discussed?
Certainly, what I'm going to do with it's in the record, and it's a 2-page memorandum from town council addressed to the Board of Appeals. And I think what's most pertinent to the issues that Nathan was raising and Attorney Connors was discussing was this. And town council says, while the applicant's letter and notations on the application form seem to want this board to determine if a quote finding unquote may be issued under General Laws, Chapter 40A, Section 6, said review and analysis is misplaced. Said Section 6 and relevant case law interpreting same permits municipalities to adopt zoning bylaws, which may be more stringent than the statute sets forth with regards to non-conforming uses and structures which are not single and two-family homes. The town of Ashland has done just that and requires that the Board of Appeals run any application through the lens of the criteria set forth in Section 3.3.2 of the bylaw. And goes on to say, indeed, the applicant's cover letter, council does recite the provisions of the bylaw as well as the controlling case law, which the board would apply under the powers test, so-called. And I think that's the applicable point. And Stu, you raised a point that I was going to raise, and Attorney Connors, it seems as though from what town council is advising us that the Ashland zoning bylaws have adopted bylaws which are more stringent than statute, which is Chapter 40A, Section 6, with regard to non-conforming uses and structures. And in fact, it seems to doesn't give the board any authority to make a finding under Chapter 6, but rather has determined that the board has to act as a special permit granting authority to proceed. And this is something that we raised early on, and I know you have consistently said that that's not required, but as I interpret what our council is telling us, we don't have the authority to grant a Section 6 finding. And unless I miss it, I'm not sure I see anything in Section 6 which specifically says we have the authority to grant to make a finding. It talks about what's necessary to continue a non-conforming pre-existing use, but it doesn't require us to make a finding. And Frank, with advice of town council saying we really can't make a finding, I'm not inclined to make a finding.
May I respond?
Certainly.
So Section 6 certainly has the word finding in it and the reasons therefore that you can make a finding. 48.6. Going to your zoning bylaw 3.3.2, in the middle of the first paragraph, it says, shall not be substantially more detrimental than the existing use. If it is not substantially more detrimental than the existing use, then we would not need a special permit. So again, we get back to substantially more detrimental than the existing non-conforming use to the neighborhood. And then 3.3.2a says a change or substantial extension of the use. Again, we're dealing with substantial extension. If we don't have a substantial extension, then it's my position we do not need a special permit. And it is your ability, therefore, to make a decision whether or not it's a substantial extension or a substantially more detrimental to the non-conforming use of the neighborhood. And that would be the finding that you would make. You can't expect any type of change on a pre-existing non-conforming use to require a special permit. Every single business that operates in town where the zoning is changed could be simply put out of business.
Well, as I'm reading 3.3.2, that's exactly what the town of Ashland bylaws provide.
I disagree. Is it substantially more detrimental? That's the question. That's the question.
And that question is addressed by way of a special permit application.
No. You may award a special permit if the change is more substantially detrimental, not if it's not. The way I read that. Only if it determines that such change shall not be substantially more detrimental. There has to be a threshold.
Well, getting back again to a question that Nathan asked, you're appealing a finding of the zoning officer, building commissioner, that there's an extension of the non-conforming use. So we have to determine whether that is correct or not. That's what's being appealed. And wouldn't our decision simply be to uphold the commissioner's finding or to overturn the commissioner's finding? I don't think it's up to us to establish what the non-conforming use of your client is, because frankly, given all of the evidence that we've heard, I'm not sure I would be able to determine that.
Well, there's a use that's increased a little bit. And is it substantial? Is it got a substantial impact of the neighborhood? I think the neighborhood has been overwhelmingly in support that it's not, and put that on the record. And the use is simply somebody that does the same type of work that the bonds do. They go out and they dig and do dirt work and stuff like that. There's a difference in landscaping. Some landscape contractors go out and mow and take care of yards, but this particular individual, as I understand it from the bonds, does actually dirt work, correct term. So that is the decision that you have to make, and we are asking you to determine, with all our information and with all the information from various abutters, that this is not a substantial change and it does not substantially impact the neighborhood. I think that's very clear.
And those are the findings that we would make under a special permit application if we were going to make findings.
Correct.
Not under section 6, because there's, again, maybe I'm misreading and not reading section 6 correctly, but
They may be extended or altered, provided no such extension or alteration shall be permitted unless there is a finding by the permit granting authority or by a special permit granting authority designated that shall not be substantially more detrimental than the existing non-conforming use. We're not changing it substantially. We don't need a special permit. That's the whole issue.
I understand your clients are claiming that there is no extension. Therefore, this wouldn't even get to this.
Well, yes, we
We would have to make, we would get to this finding if there was a contention that there was an extension or application by you. I don't see this as giving us authority to make a section 6 finding and ignoring section 3.3.2 of our zoning bylaws when our town council says that case law permits municipalities to adopt zoning bylaws, which may be more stringent than the statute. I mean, I note in one of the cases that you provided to us, and it's apparently a land court decision case, Wojcik versus Lovett, involving an East Brookfield matter. The local town ordinance also provided the same language as Section 6, whereas Ashland's 3.3.2 provides more, I would say, stringent language about how to proceed under a circumstance like this.
Well, that particular case indicates to you that you don't need to make detailed findings. That's why I included that particular case. Typically, you have to make detailed findings on special permits or variances. In this particular instance, as a finding, you do not have to do that. Notwithstanding that, if the town in particular case had more stringent requirements, as does Ashland, as you think, then again, there's the ability to make a finding. I think this is absolutely crystal clear, and I think that the application of the ability for the town to simply go out and find an extra pickup truck or an extra trailer or an extra something on a land that has a change in zoning simply makes everybody need to go get special permits. And that is not the intent of the statute.
We're not talking about everybody, sir. We're talking about your clients in this particular property, where apparently there have been some companies that have leased space, and the Bond brothers were kind enough to explain at one of our earlier hearings about what they were doing at the time of their acquisition of the property, and leasing it to one tenant who I believe left. I think the evidence was that there was another tenant who left, and now there is still a present tenant. I mean, I'm not sure we're debating whether there's an increase in the use that would warrant a finding against your clients. We may just be arguing about the proper way for that to come before the board. I understand the cases that you cited about the nature of the increase of use, and that simply having more of something doesn't constitute an increase in use necessarily, and what have you. But so I guess that's where I'm somewhat frustrated, because I don't see where we can make the type of finding that you're requesting us to make. I think we could decide, if we chose to deny or to overturn the building commissioner's decision, which would leave your clients in the present position that they're in, which is operating their business in the way that they are operating, if we were to choose to do that. But I don't see that we can make a finding, because I don't quite understand what we're going to be finding.
Well, notwithstanding that, when you indicated you'd overturn the building and you'd consider, or it's a possibility, I want to put words in your mouth, overturn the building inspector's finding or decision, we'd be happy with that. We just don't believe that we need to go for a special permit to operate on that particular piece of property as they have been. So I would leave it at that, if that's the solution to it.
Okay.
I
I do have a few more questions. Stu, did you have more questions? Because I sort of took
No, the only
over
question,
where we were.
the only question I have right now is I'd like to ask Mr. Connors just to summarize that again. His last thought.
Well, as Mr. Trefethan said, that there's a possibility you may consider overturning the building inspector's decision. And that would put the bonds back in the situation that they were prior to November 31st or whatever day that was. And that would be fine with us. We do not want to have to go get a special permit and go through all of that particular work and expense. We don't think we need it. I thought that under 48.6 was a perfectly legitimate way to use it. I never anticipated that you would overturn the building inspector's decision without an awful lot of information, which I believe we've supplied, and an awful lot of support from neighbors with respect to their operation. But we are absolutely happy if you would consider overturning the building inspector's.
Okay. A question, Attorney Connors. Who has the burden of proof in this matter?
Well,
Is the burden to overturn the decision with your clients, or is the burden on the building commissioner to uphold his decision?
Well, once a building inspector or zoning enforcement official makes a finding that, or makes a enforcement order, then it is up to us, the applicant or the petitioner, to demonstrate that he's wrong or that he's overstepped. As I indicated a little bit earlier in this, a building inspector can actually make the 48.6 finding. I indicated that in that particular letter. So clearly we have to present you enough information that we are not doing something that is substantially more impacting on the neighborhood. And we went to quite an extent on the application submission with backup documents, plans and images from Google Earth. And we also had a lot of abutters and neighbors in the area indicate that nothing has really changed on that particular piece of property as a result of this. So I think that clearly we have met more than a substantial burden.
Okay, thank you. I have a couple of questions, if I may, to your clients, and whichever Emery or the other brother, your brother, who whichever one wishes to answer. First, I would just point out, I was going through the application that was filed with all the supporting documentation, and I noticed on the quitclaim deed when you acquired the property in August of 2016, the deed references that the property is situated in Framingham. And obviously, for purposes of this proceeding, that doesn't matter. I mean, we know what we're talking about, but if at some point something is done with the property, that may become an issue. So I don't know whether you wish to talk to Attorney Connors about whether that needs to be corrected or not, but I would just point that out as something I noticed. The other thing that I noticed is that in the application, there was a copy of the filing fee check for $400, which was drawn upon Emery Industries at 59 West Union Street, Ashland. And what is Emery Industries?
That's the business that I run out of the property.
Okay. And you've been running that since the early 2000s?
Since 2004.
Okay. And what exactly does it do?
What exactly did it? We're a contracting business.
Okay. And where do you have vehicles for that business?
We have trucks, trailers, and equipment.
And where are they stored?
They're stored in the yard.
And we've looked at the various aerial views of the property, and where in the yard are they stored?
Outside in the yard. The equipment comes and goes, so, it's happenstance if it's caught on satellite video and, Google takes its picture or not. But the equipment comes and goes as the jobs require, and they're parked in the yard.
Okay. And would they enter through the drive that doesn't have a, I guess it isn't paved, it's sort of a dirt drive, as opposed to the other drive where the tenant goes in and out?
Yeah, it's a separate driveway, original to the property.
Okay. And what's the name of the tenant that's there now?
The tenant in question,
Yes.
Vitamin
I'm sorry.
D Special Garden Forces. That's the name of his company.
And that's a landscaping company?
He's a contractor. He does specialized equipment like us with excavation, landscaping, retaining walls. And as Attorney Connors mentioned, he's not a mow and go type contractor where his primary purpose of business is mowing lawns. He's a hardscape irrigation improvement contractor, much like my business.
Well, I note in the building commissioner's supplemental letter, he references that the tenant is a landscaping company, and landscaping is not something that is an allowed use in the zone that the property is in, and that it is a change in use and thus violates 3.3.
Yeah, and if I could point that out, the building commissioner's original letter, he called our tenant a contractor, and the subsequent letter, he's now calling him a landscaper. The town of Ashland does not have any bylaws that define a landscaper. If you look up the definition in the zoning bylaws, the only definition there is contractor, and we feel that our tenant meets all those criteria for the contractor status as listed in the zoning bylaws.
Okay. Okay, thank you. Any other questions by board members before we open it up for a public comment?
If I do so, John, I just want to make one note before we move forward.
I'm sorry?
Can you hear me, John?
I can, yeah.
Yeah, I just wanted to make a note. It has, I think some of you know, I was getting back to the office and digging through my emails. And it has come to my attention that the board did receive an email that I did not circulate out to the board. Today, it is via attorney Jonathan Silverstein, who's on the call tonight. But I just wanted to make a note for the record, and I apologize, John, but this did not appear until during the meeting when I was trying to dig out from my emails. So I just want to apologize, but we did receive an email correspondence with them.
Okay, well, Attorney Silverstein apparently is present and perhaps will be able to comment during public comment. Okay, why don't we go to public comment? Peter, do I need a motion to open public comment again, or can we just go and do that?
We can just move forward. Obviously, we've had that motion already made.
Okay, and you're controlling access, so Whoever, I see one hand from, I believe, Mr. Rodenheiser, whose name I remembered this time. Thank you very much. Attorney Silverstein has also got his hand raised. And Mr. Morgan has his hand raised. And Mr. DeSoni has his hand raised. So I will leave it to you to bring them in the order in which they signed on.
Thank you so much. So with that said, I will first open up to Mr. Bill. Bill, can you please unmute yourself and address the zoning board with your name and address?
Hi, William Rodenheiser, 81 West Union Street, LLC. Thanks for hearing us tonight as part of this process. I'm going to defer my time to my attorney. I just put my hand up because I didn't hear that the chair referenced the letter that was submitted, and Peter has addressed that. So thank you. One comment that I did do some research on the tenant, and it's clearly more of a landscaping type contractor, but I'll reserve my time for Mr. Silverstein. Thank you.
Whoops, we can't hear you, Mr. Silverstein, if you're talking. And
I'm not, Mr. Chair. Sorry, I was waiting
there
to
we
be
can,
recognized. But
if you could identify yourself for the record, please.
of course, of course. My name is Jonathan Silverstein, and I'm with Blattman, Bobrowski, Haverty, and Silverstein, and I'm here on behalf of 81 West Union Street LLC as well. I did, as Mr. Matchak indicated, submit a letter. It was late last night, and he's just getting back from being out of the office. So I certainly understand that the board hasn't had a chance to look at it. I hope you'll have a chance to before you deliberate and make your decision. But I'll summarize what I say in the letter now. I think there's a threshold issue here that the board needs to address. As the board no doubt is aware, in order to appeal a determination or order of a building official, that appeal has to be filed within 30 days. And in fact, here, the applicant had an exchange of emails that's attached to their application with planning staff. The former assistant town planner noted in an email in mid-November, I think November 17, that any appeal would have to be filed within 30 days. And yet this appeal was not filed until December 27, close to 2 months after issuance of the order. And, you know, I don't think that the applicant can claim they weren't aware of the order, or that somehow they were confused by the clearly, you know, typographical inadvertent error of calling it November 31st instead of October 31st. They started the email exchange on November 9th. So at the latest, they had a copy of the order on November 9th. And yet it was close to 2 months after that they filed their appeal. I cite in my letter that I know, again, you haven't seen yet, that case law is very definitive. This board does not have jurisdiction to even entertain an appeal if it has not been filed within 30 days of the order. And there's no dispute here that it wasn't filed within 30 days of the order, because there's email correspondence 50 days before the order, before the appeal, in which the applicant is acknowledging the existence of the order. And so I would submit that as a threshold matter, the board should not even rule substantively on this appeal because it's untimely, and that the appeal should be rejected on that basis alone. In my letter, I do go on to address the merits, and I'll do that now. Although again, I don't think the board needs to or has jurisdiction to address the merits of the appeal. But it's my client's position that there is no pre-existing non-conforming use as a contractor's yard, that the evidence, the prior photographs, do not support the frequent use of this property for storage of heavy equipment and dumpsters and the like. that it may have had the occasional pickup truck on the property, but it was not used as a contractor's yard. They may have registered their business out of that property, but that doesn't make the use of the land a contractor's yard. And that's a use that began subsequent to the 2017 amendment. 2019 amendment. And therefore, there is no pre-existing non-conforming use protection in the first instance. To the extent there is a pre-existing non-conforming use as a contractor's yard, there certainly wasn't one as a landscape business, and your use table separates out those terms. And the fact that one is defined and one is not doesn't make a difference. Everyone has a concept of what a landscaping business is, and that's clearly what has moved into the front building, which was never previously used for any commercial purpose. And in my letter, I sort of run through some of the primary differences between the use of the property prior to 2019 and the use of the property since then, not the least of which is storage of a large roll-off dumpster, substantial clearing of the site, grading of the site, and storage of heavy contracting equipment, which was never previously used on the site and in areas of the site that were never previously used. And I would also note that they've built new structures, and case law is very clear that as soon as you build a new structure, that goes beyond any pre-existing non-conforming use protection that may have existed. And I cite in my letter the case of Cullen versus Building Inspector of North Attleboro and Planning Board of Reading versus Board of Appeals of Reading. And that's very clear that any construction of a new structure, in this case, there's the building, there's the retaining wall, there's all sorts of additional construction that's taking place on that property. There's been no groundwater, stormwater permit obtained for all of the land disturbance they did on the site, despite the fact that your bylaws require it. There's been no building permits pulled for the residential tenant in the basement. It's essentially anything goes on this property. It's clearly not reflective of what took place prior to 2019, and clearly beyond any pre-existing non-conforming use that may have existed. And then finally, I want to set to rest any notion that this board can or should make a finding outside of the context of a special permit. And Mr. Connors cited to the East Brookfield case. I'm going to just read you one short quote from that case. East Brookfield, having chosen in its bylaw to treat Section 6 findings separately and as something distinctly other than special permits, was not obligated to make the kind of detailed findings in support of Section 6 finding that it would have been required to make to justify the issuance of a special permit. Completely different bylaw. Unlike the East Brookfield bylaw, Ashfield's bylaw very clearly, unambiguously requires that any Section 6 finding be made in the context of a special permit. No special permit's been asked for here. There's been no application for a special permit. And in any event, we would submit that for reasons outlined in my letter, including dust, increased dust, noise, erosion, garbage blowing out of the dumpster, that the board could not find that the new use that's taking place on that property is not substantially more detrimental to the neighborhood than whatever use predated the 2019 amendment. So there's a lot more detail in my letter, but I know that there are probably others who want to comment. I've tried to be as succinct as I can. I'm happy to answer any questions that the board may have, and I do appreciate your time.
Thank you, Attorney Silverstein. John, if I can keep moving. Oh, I can't hear you. You're on mute.
Unmuted myself. Have I unmuted myself now?
Yes.
Technology is wonderful. Thank you. we apologize for not having the opportunity to read your letter. We will read your letter before we enter into deliberations. I see that there are two other people who wish to comment. And once we finish with public comment, we'll go back because I suspect there will be further questions and further items that Attorney Connors may wish to respond to. Peter, who is next on the public comment list?
I'm gonna introduce Mr. Mark Dessoni. Mr. Mark Dessoni, can you please unmute yourself and introduce yourself with your name and address to the Zoning Board of Appeals, please?
Okay, thank you. I'm introducing Mark Dessoni, 49 Hawthorne Road. And yeah, I've been following this for a while. I have maybe a couple of questions out of this. When this land was bought in 2004, what was the original intent for this land?
Mark, the land wasn't bought in 2004. The present applicants bought it in 2016, but I believe Mr. Bond said that that company Emery was created and began operating around 2004, if I've characterized it correctly.
Okay. And for being bought 2016 then, and having the Emery name, was there a specialty that was going to be used for to get started with?
I don't understand the question.
Okay, through the chairman, to Mr. Bond.
Oh, I see.
The idea of your contractor service, was there a specialty contract service that was going to get you going?
Hey, may I respond to that?
Certainly, Ms. Attorney Connors.
And the bonds can simply assert to this. But it's my understanding that prior to them acquiring their father's property, he was doing the same type of thing and they simply took over. Is that correct, Mr. Bond?
Yeah, that's correct.
Okay. Took over from when and how?
From 1975 to 2016.
And at that time, 1975 to that time, there was some sort of an idea of what you're going to be using it for?
That predated my time, but yeah, the intent was to continue to use it as contractor construction yard.
Okay, now to shoot up to 2016 to now present time, were you still the only owner on that property doing what you're doing now?
Yes, correct.
When did the other tenants come? What year?
Mark, this was all talked about at the hearing on February 28th, when Mr. Bond indicated that the first tenant was 2017. That tenant left, another tenant replaced it. I believe that tenant left during the pandemic, and then the current tenant began leasing the property. But that's in substance what it is, I believe. That's what the testimony was. And, I don't want to go back all the way over
Okay.
what we've covered in two previous hearings.
Okay, I understand. So there was multiple tenants. Was there between the multiple tenants, one left and come, left and come, left and come? Was there building conditions through building management that changes companies and changes personnel?
That's not relevant to what we're talking about.
Because I'm trying to understand, okay, thank you for that saying that. I'm trying to understand that different can be different if it is different from the original. But now, the tenant that's there now is a specialized groundskeeper equipment worker, right?
You heard the applicant testify tonight what the tenant does, yes.
And this tenant now that's there is a ground keeper with different equipment for different uses. Yes or no?
You heard the testimony, Mark. You've been at the entire meeting tonight and you've heard the testimony. I'm not going to have you go over the testimony and get confirmation or not. If you want to be heard and speak about the project and about the application, fine, but we're not going to go through the evidence piece by piece.
Thank you for that. I'll only be upon listen a minute then. I'm trying to go down a two-way street looking and trying to compromise so everybody can be settled on what's going on here. I was just wondering about that zoning codes, that 6.32 zoning code. Does it have all to do with the building commissioner's decision, or is that going to be a separate addendum to the decision? Thank you.
Okay, thank you, Mark. Peter, I see one more hand up, Mr. Morgan.
The last hand will be Mr. Stephen Morgan. Mr. Steve Morgan, excuse me, Steve Morgan. Can you please unmute yourself and introduce yourself to the board with your name and address?
Yeah, sure. Steve Morgan, 136 Concord Street. Am I coming through, Peter?
Mm-hmm.
All right, great.
Yes.
So respecting your comment to stay on new material, Mr. Chair, I thank you for reopening the public comment and in doing so, allowing the public engagement. I do like to provide a couple of additional pieces of information. First, while we've been listening here, I reviewed the record at the Mass Corporation site. This business, Bremerly Industries LLC, was actually formed in 2014. And it has a certificate here on section 3 indicating it is a general carpeting / remodeling and compact equipment service. There's no mention of a contractor yard or landscaping, and this is a public record that any board member can pull on their own. So I'd like to pass that information on to the board. I think there's some inaccuracy as to when the business started that was just reported. But it's clearly indicated 1/7/2014 was when this organization was formed. Second point I'd like to make, which again is currently a public record, maybe it won't be there shortly, but there's a series of photos out on Facebook for this business, July 2nd, 2022 and June 12th, 2022. And they clearly show all of this construction that's at issue occurring and being posted for the public's consumption. That puts a time and a date on when these changes were made. It shows the before and after and how extensive the changes were. And these are, again, public records on Facebook. Unless they're taken down, they'll be there for the board to see. I was easily able to find them. They're on the applicant's page. It's very clear from these chronological photos that, as has been suggested, substantial changes were made to the site, including installing excavations, buildings, fences, etc. So I think those are very, very helpful for the board. And I pass them on for the board to understand their existence and submit them, by link, if you will. And with that said, I just had one other comment relating to the positioning of the complaint. I don't think we really talked to this before, but I agree with the assessment that the board should defer to the public official. I think the official did a good job in coming back to the ZBA. I've read his letter, and he clearly lays out why he issued this order. there seems little question that there are additional tenants, additional space, and additional uses at the property. I think he was well-founded in his conclusion. And I would appreciate the board as a resident ensuring that the zoning code is followed. So that's my final comment. Thank you for the time.
Thank you, Mr. Morgan. Anyone else from the public wish to be
Yeah,
heard?
I'd like just to respond to that. So obviously the property's on West Union Street, which is a major thoroughfare in Ashland. And we did that work out in the open, so it doesn't matter if it's on Facebook or if you drive by the property, we weren't looking to hide anything. So in regards to the business structure, I got my doing business as certificate from the town of Ashland in 2004, and then back in 2013, 2014, we changed our business structure to an LLC. So that's where the discrepancies in the dates are. But going back to 2004, doing business license certificate from the town of Ashland was issued for the property.
Okay. My apologies, I may have misspoke about what started when and got everybody confused. So I think we're on the same page. No one else from the public wishing to be heard? Oops. Mr. Rodenheiser, is that your hand going up, or are you
Yeah,
just waving to it?
Yeah, just one other quick comment. I was able to go on the web, search the web up for vitamin B. And Mr. Bond had also made some comments about how they were a company just like his. If one goes on to their website, you can clearly see a great deal of pictures of flowers and predominantly a landscaping type business, which does also further back up the point made by the building official. And Mr. Bond also, when asked by Mr. Connors if his father did the same thing that he did as early back as, I don't know, 1970, whatever it was, said, oh yeah, he did the same thing. And I think it would probably be interesting if the board decides to see those records that they did the similar things that the Bonds do with heavy equipment. Thank you very much.
Okay, thank you. If that is the end of public comment, would someone wish to make a motion to end public comment, or to close public comment, I guess I should officially say?
So moved.
And is there a second?
Seconded.
I, John Trefethen, vote in favor.
I, Brian Forrest, I'll vote in favor.
I, Nathan Band, vote in favor.
I, Stuart Siegel, vote in favor.
I, Ryan Sullivan, vote in favor.
Excellent. Before we go to Attorney Connors, I just wanted to raise something that Attorney Silverstein raised, and this was the first time during this hearing that this subject has been raised, and that was namely the timeliness of the filing of the appeal. I believe we're all in agreement that it has to be filed within 30 days of the building commissioner's order. And we've been operating off of a letter dated November 31st, 2022. And we all know that there is no November 31st. And I think we were, just my wife sneezing, my apologies, that we were just operating on it was a typo and it should have been November 30th. However, the point raised by Attorney Silverstein caused me to go and review further along in the application that has been filed with the board that brings us here tonight. And among the documents included or attached to that application is a 4-page email from Emery Bond dated Wednesday, November 9th, addressed to Mr. Scott, the building commissioner, with copies to Peter Matchik and others in the town. And it says, and I quote, "Hello, Doug. I am in receipt of your certified letter regarding 59 West Union Street in Ashland, Mass., dated November 31st, 2022. Your letter revolves around two topics. One, the presumed increased business footprint And 2, the accessory structure that is in the area that you specified in your letter. I would like to have you review the information provided below and also have you clarify the points in your letter. And then the email goes on for 4 pages, and it was sent Wednesday, November 9th, 2022 at 7:15 a.m. So it would appear that the building commissioner's letter, rather than being misdated November 31st, was dated, should have been dated October 31st, because it was received by the applicant no later than November 9th. So are we in a situation where the appeal was not timely filed? At which point that would end our discussion, I would submit. And Attorney Connors, I guess I would, ask you to respond and maybe give others on the board a chance to inquire about it as well.
Well, I have the November 31st dated letter, and that's what I went on. Subsequent to that, there was additional information that was supplied to me. I don't necessarily know when indeed the emails were, but I guess they speak for themselves. I would have to research this a little bit more.
Well, I think we can all agree that there is no November 31st as a date. The application was filed December 27th. It would appear that your client had notice of the building commissioner's order no later than November 9th, when he wrote his lengthy email to Mr. Scott, asking some questions and enclosing some further information. And then subsequently, there's an email from Mr. Scott dated November 9th at 7:36 a.m. And certainly the town's getting its money worth from him starting that early in the morning. Addressed to Dear Mr. Bond, as I stated in my letter, you may file an appeal on my determination or cease allowing the tenant to use the space to the right of the house and remove the accessory structure. Those are your options. So whatever the date of the letter is, it would seem that your client had at the very least constructive notice of the building commissioner's decision, and there is no disagreement. The appeal of the application to the Zoning Board of Appeals was filed on December 22nd of December 27th of 2022, which would be more than 30 days.
I would need to do some research on the dates. I'm not I, for one, would certainly be willing to grant you that time. I suspect my fellow board members also. Perhaps, let me hear from you. I don't want to presuppose. Brian, thoughts about giving Attorney Connors an opportunity to review this somewhat new information, and would also give us an opportunity to review Attorney Silverstein's letter to us.
Yeah, it seems like we're gonna need to review Attorney Silverstein's letter anyway. Seems pretty clear cut to me, but if Attorney Connors wants to investigate the dates, have at it.
Thank you.
Nathan, your thoughts on the matter?
Yeah, I'm with Brian. I think we need to look at Attorney Silverstein's letter. The math seems pretty clear cut on the dates, but maybe Attorney Connors will surprise us with, legal theories that the date matter.
We do have the November 31st date, which is not a date that exists in the calendar, but we shall see. Stu, your thoughts on it?
I concur with the other board members.
Okay. And Ryan, how about you?
I concur as well. I do, think if there is authority, Attorney Connors, that you could cite to with respect to the misdating, that might be helpful as well to see if that provides any relief as to the deadline.
Exactly.
Thank you.
Okay, so today is April 11th. Our next regularly scheduled meeting would be
25th.
April 25th. That give you enough time to research and come back to us, Attorney Connors?
Yes, it does. Thank you.
And if you find anything and put it in written form, if you could please submit it to Peter at the planning department so he can distribute it to us before the meeting. It's always helpful to have an opportunity to review the legal briefs. Okay. So I think we are in agreement that we will continue the matter to April 25th at 7 p.m. Does someone wish to make a motion to that effect?
So moved, John.
And is there a second on that?
Seconded.
Okay. I, John Trefethen, vote in favor.
Hi, Brian Forrest. I'll vote in favor.
I, Nathan Band, vote in favor.
I, Stuart Siegel, vote in favor.
I, Ryan Sullivan, vote in favor.
Excellent. Okay, this matter is continued then to Tuesday, April 25th at 7 p.m. And thank you all. Thank you to the members of the public that tuned in. Attorney Silverstein, thank you for your submission, which we will have an opportunity to read. And we will see any of you that wish to come back on April 25th. Thank you very much.
Thank you. Good night.
Good night.